Hi there, Emily Farber with Lepic Crager Realtors in Iowa City, Iowa. Thanks for joining me. Today's video covers the topic of what happens if you change your mind. Buyers, you enter a contract, all is going grand until suddenly it's not. You've had a change of heart, you've got cold feet, your circumstances have changed. Whatever the reason, you no longer wish to buy the home that you have set forth. What do you do now? What might happen? What could be the potential outcomes of such a decision? Stay tuned. All right, let me start this off by saying I am not an attorney. I don't play one on TV. I don't have a night job as an attorney. So if you have legal questions, I highly recommend that you consult a real estate attorney. When you find a property that you're interested in and you write a purchase agreement on it, you enter a legal and binding contract once the terms of that agreement have been met. If it's got a buyer's signature, a seller's signature, and there has been consideration, aka earnest money, presented and accepted, you are in a legal and binding contract. Now, if you change your mind right away, before the seller has even signed, there still is time to back out. Have your agent write a written withdrawal with a timestamp on it and have that presented to the seller's agent. No harm, no foul. You've stopped everything before it even gets moving forward. But if you are already into an accepted purchase agreement, things are a little bit stickier if you change your mind. Part of your purchase agreement should include several different contingencies which are there to protect you as the buyer and provide potential exits out of the contract if you may need them. Some examples of common contingencies are inspections. If something comes up upon your inspection that you can't live with, that you're very concerned about, and that you and the seller cannot come to terms with on how that is going to be dealt with, that provides you with an exit out of the contract where you can legally leave the contract and have the earnest money returned to you. Some other common contingencies in purchase agreements are financing. If your financing falls through, that provides another exit for you to leave the contract and keep your earnest money. As you work your way through your contingencies and do your due diligence of investigations, eventually you have to release those contingencies in writing. Once a contingency is released, it's like that exit door is shut. That is no longer an option for you. Eventually you will reach a point in the contract where all of those exit doors are shut and you're just waiting for closing. So what happens if something changes? You freak out and you get cold feet, your circumstances change, maybe you got a job promotion and you're leaving the area, maybe you and your spouse are having problems and you don't think that buying a house together at that time is a good idea. There's many different reasons why things like this happen. People sometimes do change their minds. So then what? Well, chances are likely that the seller is going to be quite aggravated. I'm sure you can understand why. You've essentially asked them to take their house off the market and put all their eggs in your proverbial basket. At the very least, you should expect the seller to keep your earnest money, however much that might be. It could get worse than just them keeping your earnest money. You should know that you could potentially be sued for specific performance or failure to perform. If you're sued for specific performance, a court could order you to purchase the property. Another outcome is that you may be sued for failure to perform, in which case you could be sued for damages. The damages go beyond what you might think they include. Those damages could include things like the difference between the purchase price that you agreed on and whatever future buyer offers. If there's a difference between those two prices, the seller may ask you to make up the difference. The seller may also ask you to pay for the carrying costs until the house is sold a second time around. Those carrying costs include things like mortgage payments, utilities, yard care, all of the things that it takes to keep the house running during that time until it is sold again. You might also have to foot the bill for the seller's legal expenses. It is not inexpensive to get out of a purchase agreement, and it can go far beyond just losing your earnest money. If you find yourself in a situation where you think that you need to exit your purchase agreement, I highly, highly recommend that you speak openly about your concerns with your realtor. Do not keep your realtor in the dark. The more open the communication, the more likely it is to go smoothly. I also can't stress this enough, but you need to speak to a real estate attorney. Talk to an attorney who is going to be able to guide you through the process and help you find an exit with the least amount of financial and legal ramifications for your case. I hope you found this video helpful, and I hope that you don't ever find yourself in this situation. But if life has taught me anything, it has taught me that nothing is predictable. We don't always know how things are going to turn out. As always, I put out videos every Friday, if not more often, and I'd love to have you join me. They focus on all things real estate, feature stories about the greater Iowa City area, and easy do-it-yourself projects. I'll catch you next time.